Hello and welcome, everyone. Today, we're going to look at 4 different jurisdictions: Russia, France, Singapore, and Denmark, and how their civil and criminal legal system regulates or deals with surveillance. I'm delighted to be joined by 4 of our illustrious IFG, International Fraud Group members. Alexander Ratnikov from our friends Pen and Paper in Moscow, welcome. Ardavan Aslani from our friends in Paris, welcome. Lionel Chan from Ulaanbaatar in Singapore. Thomas Whitemeyer from Molen Whitemeyer in Copenhagen. I'm going to start, Alexander, with you and ask you to tell us about investigators in Russia, for example. Do they need to be licensed to conduct investigations? Then what kind of covert surveillance can they do?
There are quite a few investigators in Russia and they need to be licensed. They need to apply for a Russian National Guard, a special agency which deals with the licensing. They can survey people, but they need, the irony is that they need a special agreement with the people whom they cover. So ideally, if I'm a private investigator, I need to investigate for his agreement to do so. So when you say about covert surveillance, basically illegally in Russia, it's, very difficult.
It's perfectly legal provided they agree to be surveilled.
Yes.
Okay, I'm going to ask our good friend Ardi in France. What's the story there, Ardi?
Basically speaking, in France, investigators are members of a regulated profession and they need to be licensed. However, as far as the exercise of their mission assignment is concerned, they obviously do not need the authorization of the person that they are covering. And covert investigations are thus authorized.
Would everyone have to be licensed, or is it like an organization as long as one person is licensed?
We have to distinguish between what we call business intelligence at large and what we refer to as active investigation, which could imply following a person around the public area and acts of this nature. However, those who are involved in active investigation, individuals, they would require to be licensed.
Singapore, Lionel, does it follow an English example, or are you much more regulated?
In Singapore, if you want to be a private investigator, you have to get a license. But the license doesn't allow you to do anything extra from what the ordinary citizen can do. I think the interesting thing about Singapore, even though it's a commonwealth or common law jurisdiction, is that it doesn't have a privacy protection legislation. You can conduct surveillance, but there's also some exceptions. But generally speaking, those are generally allowed.
Tell us how Denmark looks at this particular area, please, Thomas.
We have a regulation whereby private parties and investigations or investigators, they are not regulated by any special legislation in Denmark. And therefore, they are subject to the same legal rights and obligations as everybody else. So you cannot observe anybody in their own home or at their own domestic place. So you have to do it out in the open. So you can follow them on the street and you can contact them, and you can, of course, if you get a consent, you can take pictures of them, but else you can't.
So just coming back to you, Alexander, in Russia, if I'm a meeting with you in a cafe and I put my suitcase or my briefcase rather on the floor with a microphone in it, am I breaching the law in Russia?
So if it's for your private use, I suppose, it's kind of perfectly legal. But if, on the other hand, you want to use it in the legal proceedings, it's kind of a different story. In order to make it, court admissible, you needed to ask a person for his authorization to do it.
Otherwise, what will happen? The judge will simply not admit it as evidence.
Yeah, absolutely.
But would the person concerned finds out, because I say to him, oh, look, I recorded our conversation last week. Can I use it as evidence? Will I be liable for any criminal or civil offense?
As I say, it happens very rarely. And I think it's kind of very difficult to legally prove that you did something wrong. If it's only one conversation, not if it's kind of permanent surveillance.
In France, what's the story if I wanted to record?
As a matter of general rule, you cannot record someone without their prior consent, unless you belong to a specific profession that is regulated, such as the banking community or these brokerage firms, where you are authorized to record them, subject to having informed them in advance. However, once again, another distinction is whether the recording is being utilized for personal matters or for civil or criminal proceedings. In civil matters, recording someone's voice cannot be utilized as a corroborating proof in civil litigation matters. However, in criminal matters, proof is totally free, which basically implies that you can record someone without their prior consent and file it in a criminal proceeding and have the judge utilize that.
Can you think of an interesting case that either you or either you've been involved in or you're aware of that applies the law relating to investigations, to give us a real life example?
We had a case a couple of months ago whereby it was about some fraudulence in a building area where some of the entrepreneurs had, like, instead of just ordering for the buildings had to be built also for themselves. And there we hooked up with some investigators to, like, follow them, take pictures of where the building material has been used, and that was probably not in the public area, but more, as you say, over the fence and on the private domain. In Denmark, it's up to the court to decide whether you could, even though you have, like, stepped over the boundaries of what you could and couldn't, it's up to the court to decide whether they would allow it or not.
Lionel, what's the position in Singapore? Anything that you can think of recently or that would give us a flavor of the way that the Singaporean court looks at this whole area?
For criminal matters, I think it's very liberally accepted by the courts. The balance seems to always be on the side of admitting the evidence. So, for instance, there are cases whereby there's an entrapment by, I think, a private citizen, and these evidence are basically admitted into evidence. So the same actually standard actually appeared to be applicable for civil matters as well. But I think the courts are also a bit more hesitant to admit such evidence in civil cases. I think the reason for that is that they see that it's difficult to assess the probative value in a civil case. So one example I can think of is this AMB and ANC case. This was a wife who was involved in divorce proceedings. She got a locksmith to open the lock and then access the computer of the husband to try to use this information and evidence in the courts. So the husband applied for injunction, and the court granted that injunction.
So I'm wondering what the position in Russia would be, Alexander, if a husband and wife are living together. Can she walk into the husband's study and take an image of his computer, or is that going to be met with sanctions?
It all depends on legal issues, whose property she is investigating. If it's their shared property, they both have claims for the property. It's perfectly, I suppose it's perfectly fine. But if on the other hand, something belongs to the husband and it's kind of legal, and he has some kind of legal protection, for example, they have some kind of a marriage agreement, and then, I doubt it, but it all depends on tiny legal technicalities. In criminal proceedings in Russia, usually it's kind of the police, the evidence collected by the police that matters.
Adi, what would the position be in France?
Once again, it's going to be dependent upon the nature of the marital contract between husband and wife. If, for example, the wife were supposed to be married in a system where there's no marital contract that was established, basically speaking, all of the assets of the shared community of marriage are shared by both parties. So there is no legal ground on one side or the other to initiate any proceedings. The only instance, if I dare say, that there could be a problem would be in the instance of a divorce, whereby, although divorce for fault doesn't exist in France, you don't need to prove one of the husband or wife's behavior as being a wrongdoing for you to be able to initiate divorce, as the concept of marital betrayal no longer exists in France. Bearing in mind that there is a French tax authority antenna at the courthouse, and the French tax authorities always ask for and gain access to marital documentation in case of divorce, so as to identify whether any tax wrongdoing has been done. This is considered as admissible practice in France.
Sorry, let me summarize what I think I understood, that the wife's evidence of what she had taken from the husband's computer would be allowed, it would be
Yes.
weighed up?
Yes. Systematically, in large, high-profile divorces, they ask for the communication of the writs of lawyers, both sides. The courts in civil matrimonial disputes are very much interested in determining what is the exact financial surplus of the couple, so as to be able to be in a better position to allocate alimonies, depending upon what was agreed in advance or not.
Changing topic slightly, going to you, Thomas, what can you do in the workplace? Could I pop in and out of, as an employer, pop in and out of my employees' emails in Denmark?
You will have the right to drop into their mailbox and look at every mail connected to their work. Normally, you should inform them by a personal handbook or something like that. That you have the access and you will use it to some extent. You will have to avoid stepping into anything marked as private. Then you are exposing yourself into a criminal case against you. So if you open a letter for somebody, digging into their mailbox, marked private or something like that, then you're actually stepping over the criminal laws in Denmark.
Lionel, what's the story there with internal, as it were, surveillance and monitoring?
If you mark your work emails private, I think the employer can also look at them. So don't do that in Singapore. Yeah.
Don't do that in Singapore. Some investigators, they go and pick up what is called the rubbish or the trash. But could I go and pick up your rubbish and have a look through it?
Yes, you can.
Excellent news. Adi, what about in France?
The intention of the prying eyes is of importance. If something is thrown into the public domain with the understanding that it may be utilized by third parties for whatever initiative, there is not much that the person can do about it. If the investigation is interested in discovering confidential information about that person with the intention of using it in a prosecution or court, well, that could entail people's liability in civil matters, not in criminal matters.
What about trash collection in Denmark? I bet you good old Danish citizens have never even thought about doing such a scurrilous thing, right?
Well, I think it would be similar to France, actually. That would be the short answer.
Okay. And Lionel, are Singaporeans very protective about their rubbish, or do they not care who gets hold of it?
You can do it at your peril. Someone who takes your trash can probably use that evidence against you. Yeah.
If I stuck a tracker underneath your car, is there something wrong with that fed back information so I could see what posh restaurants you're going to during COVID and dob you into the authorities?
You can follow me. So if you sit in your car just behind me and just right next to me or behind me all the way, that's okay. But putting in some surveillance on me or my bike, as we use in Copenhagen, or car.
Of course,
yeah,
cars, yes.
That's not allowed.
Okay. Adi, can I follow you around to your various posh nightclubs?
Well, unfortunately, no posh nightclubs lately because they've been shut down for a year now. Same thing for restaurants.
Right.
That is illegal in France. Of course, that cannot be done, as it was mentioned in Australia. Same case applies.
What about Singapore, Lionel? What's the story there?
I'm not sure whether you can argue that this is unlawful stalking. It depends on the intention. And I think it may be, if the intention was to cause distress, that may be a problem. But otherwise, I think that should not pose an issue.
On that note, I am going to say thank you to each and every one of you for a really interesting and entertaining morning, evening, afternoon's discussion. And I hope to be back with another group of IFG members in a month or so to cover what their local jurisdiction says about surveillance, stalking, harassment. But thank you all very much,
Thank you.
and be in touch soon. Bye-bye now.
Thank you. Goodbye.